Welcome to TechLaw10. This is number 298. We're approaching 300 and still going strong. My name is Eric Sinrod. I'm with the law firm Duane Morris. I'm joined as ever by my colleague Jonathan Armstrong. I'll be turning it over to Jonathan in just a moment, but I'm going to introduce today's topic. Today's topic is, drum roll please, OpenClaw. What is OpenClaw? OpenClaw is a powerful open source software framework that lets you create your own personal AI assistant. It gives any AI model like those from Anthropic, Google, or OpenAI the ability to interact with your digital world. It's designed to be run locally on your own devices like Mac, Linux, and Windows. Unlike a chatbot you open in a browser, an OpenClaw agent can run 24/7. It can perform tasks autonomously, like managing your email, planning a trip, or even writing code while you sleep. It integrates directly with messaging apps you already use, such as WhatsApp, Telegram, Slack, Discord, and iMessage, and you can also interact with it via a dedicated app on your own Mac OS, iOS, or Android device. You can give it access to tools like a web browser, your files, and a canvas for visual tasks, and it can even create sub-agents to handle complex multi-step tasks. So all good? Not necessarily, which is why probably we're here. We need to deal with some potential significant security risks. Chief concern is referred to as prompt injection. An attacker could hide malicious instructions in an email or on a website that your OpenClaw agent reads. Because the agent can't easily distinguish between a user's command and external data, it could be tricked into following the attacker's orders, potentially exposing your data. And then there are vulnerabilities and misconfiguration. As an open source tool, OpenClaw has been heavily targeted by hackers. Security audits have found hundreds of vulnerabilities, and many users have accidentally left their assistants exposed online without any password protection. Security researchers have referred to this as an absolute nightmare from a security perspective, but now we're all waiting to hear from Jonathan Armstrong to set us straight. Jonathan?
Yeah, thanks for setting the scene. I mean, I think that's a great introduction. I suppose in my simple terms, the way I look at OpenClaw, and by the way, it's been called Maltbot and Claude in its short life. Note, not Maltbook, which is something completely different. But it's almost like a sort of a mixture of a password wallet on steroids and Moneypenny from the James Bond films, if that's not overly descriptive. And as you say, it's a willing helper that will help get tasks done. But it's not been in existence very long. It was started up towards the end of last year, 2025, by a guy called Peter Steinberger. And he said it was a weekend project. It became very popular very quickly, had 2 million visitors to the code repository in 1 week. And as you say, by early February, the 9th of February, we'd had this report on security vulnerabilities. And that in itself is an indication of how popular it's become. The vulnerability report suggested that there were 42,000 IP addresses potentially compromised in 82 countries, with 50,000 devices potentially vulnerable. And as you said, this theoretically at least would enable threat actors to execute commands, to send emails, to remember stuff that you were doing, like a keyword logger, like a keyboard logger would do. And there's no need for employees, for example, to upload stuff, because once it's there on the device, then it can observe and learn. And And I was very interested in a paper that Darren Williams of Black Fog wrote about how this is different from a number of other vulnerabilities because of this sort of always on, always there presence. Now, I think maybe the other thing to say is this is just another example of the issues of shadow AI. And I think it's likely to be a shadow AI tool in most cases. I think some organizations may have looked at OpenClaw and done due diligence. I suspect very, very few. And I suspect they'd have struggled to legitimize use of OpenClaw because it hasn't been there that long, because contractual provisions are unlikely to work. So, in the main, this will have been a tool that individual developers, either employed by the organization or subcontracted, will have been using to get stuff done. And we've talked before about the issues of shadow AI. I think there's a Microsoft survey that says 71% of employees in the UK admit to using shadow AI, and I underline admit to. I suspect most employees are using some form of AI at work. And as you said, because this is a resistant tool, it's hard to uninstall, hard to reverse, and it sits and remembers stuff. So as soon as the vulnerabilities were reported, I think we had regulators on the scene here in Europe. The first on the scene was the Dutch Data Protection Authority, the Autoritas Belangenheffens, and they had issued a report by the 12th of February, so just 3 days. This is another trend we're seeing in AI, with regulators getting on the scene very quickly. We saw that, for example, with DeepSeek, with Replica, with ChatGPT, and they effectively reminded organizations that it was their obligation to make sure that personal data was secure under Article 32 of GDPR and the sixth principle, which says you have to ensure that data is secure and kept with integrity. And we've seen that regulatory opinion followed in other jurisdictions, Hong Kong, for example, this week. And I think it's important to look at this, as I say, as part of a trend. Obviously, OpenClaw is an issue, but there are other issues with other AI apps as well. The BBC has done an investigation into something called Orchids, which is a vibe coding tool, i.e. a tool that will develop code for you to build apps, to do things. And there are clearly real risks here. I think the first risk is obviously going to be that anything that is free has to be treated with suspicion. The inventor of OpenClaw himself said it wasn't fit for the purpose that it was being used for. And for most organizations to meet your GDPR Article 32 obligations or your obligations under NIS or DORA, you have to use software that's resilient and fit for purpose. And free is unlikely to do the job in most cases. So I guess now that we've outlined the problem, have we got any practical tips? I've maybe got 8 things that organizations could think about. So first of all, technical settings. As we said, not as easy as some stuff because of the way in which OpenClaw works, but you'll need to look at technical settings. Secondly, look at your social media output. Some people configured OpenClaw to also manage their socials for them. So reputation is very important. If this is potentially compromised, then that could have other effects as well. We know, for example, that compromised social media accounts have been used to push Bitcoin and cryptocurrencies, etc. Thirdly, you might want to look at the spending on LLMs, on your legitimate LLM accounts, because OpenClaw usually has the passwords and ability to instruct those LLMs, and threat actors could be using your computing power to do other things like phishing attacks, like projects on their behalf. Fourthly, revisit AI literacy. We've talked about this before, and by the way, people can access the links to earlier podcasts via YouTube or the audio versions. But AI literacy has been a legal requirement for most organizations since last February. You need to adapt your AI literacy program to cope with new developments, OpenClaw 1. Fifth, look at the whole issue around ShadowAI. There are two types of organizations. I think those that are using AI legitimately and those that don't know that their employees are using AI. So obviously, it's always easier if you've got a legitimate AI platforms that you're pushing employees to. Banning AI just does not work. Number 6, look at your contracts and due diligence. With small companies, it'll be harder to get them through any good due diligence tests. This might be a risk that the business is prepared to take, particularly in the AI world, since some organizations are smaller, but at least have that conscious decision that you're taking that risk. You can maybe put insurance in place. You can maybe ask for some other forms of indemnities, reassurance, use a code checker to check the code, etc., etc., etc. 7th, something that's mentioned by the Dutch regulator, look at a data protection impact assessment or an AI impact assessment. That may be a legal requirement. Even if it's not a legal requirement, it's good practice. And then number 8, if you have detected OpenClaw on your networks, then you're obviously going to have to look to see if you've got any regulatory reporting requirements. That might be under GDPR, might be under NIS, might be under DORA, might be under a raft of other legislation that we've talked about before, but that might trigger some regulatory reporting requirement, might trigger an obligation to report to customers. Best not to bury your head in the sand and look at whether you need to do anything about that.
Well done, sir. I was going to ask you what your thoughts and recommendations were, and there you go. I have 2 questions, and I have an update from on our side of the pond. First question, you've mentioned properly that ShadowAI is used so much by employees, and I suppose, do you have any further comments on how employers should specifically deal with employees using ShadowAI? That's my
It's a
first
great
one.
question. I don't think there's an easy answer. I think part of the answer is carrot, not stick. I think that oftentimes those using ShadowAI are those more junior in the organization. And the statistics or the surveys say that those entering organizations may be under 25, 26, that type of age. The surveys tell us are more task focused. So even if that means not obeying the company's policies, they'll disregard the policies to get the job done. So I think you've got to reset some of that. And that's not just a thou shalt follow my policies. It's not giving somebody a ring binder of policies, as I've seen one client do, and say to a junior member of staff, read this ring binder before you do anything. I think it's explaining the risks. It's explaining, using, proper engagement techniques, explaining what that risk is, and then trying to get those junior members of staff on board. And that probably includes involving them in designing your policies and procedures, because they'll know most of the loopholes. I thought it's interesting. I once saw a thing about, I don't know whether you have it, but roads in parks, in public parks. So you can either set out the tarmacked roads in advance, or you can have no paths at all, see which way employees walk, and then adapt to the patterns that they have. And I think that's not a decent strategy with ShadowAI. Ask somebody who is taking shortcuts across the park to join your team, deciding what the preventative measures should be.
Okay, second question before my update. You mentioned the idea of being suspect if something is for free in this realm. Is there the possibility then that somebody could just slap a price tag on it and call it not free, and it's still suspect? It's still the same thing?
I think that is a real worry. And where we've seen announcements recently, I think the inventor himself is going to one large AI business. Another tech business has said that it's adapting OpenClaw to be a more secure and safe version, but under its brand to make it do similar things. But I think you're right that oftentimes, whenever the code is sort of freely available, it can be incorporated into other things. So those vulnerabilities could still exist even with a paid for product. And that, I think, is why some people will look at technology to try and look at exactly what's happening on the device rather than the brand of the program, if you follow me. So they'll look at the functionality rather than the name. Although obviously with things like OpenClaw, because of the way it's set up and the repositories it uses, etc., it's relatively easy to find. Or so I'm told from people more technical than me.
You're doing well. Brief update over here, maybe not
Yeah.
directly on point, but it's certainly in the AI sphere. There's now litigation in federal court, I believe, in San Francisco and Washington, D.C., by Anthropic against uh, truly our Department of Defense, but now called our Department of War, because as part of potential work between Anthropic and the Department of Defense, Anthropic trying to consider itself as sort of the more safe, secure, privacy protected AI, did not want to engage in some sort of means of allowing our federal government possibly to have the ability to have greater surveillance over citizens in the United States. And so that caused a conflict there. And Anthropic's been sort of branded by the government as not potentially trustworthy. And there's friction and
Mhm.
litigation. And I don't know if the news of that's made its way over to your part of the woods or not, but I just thought I'd at least provide that update here.
Yeah, we have followed it, and I think it is interesting. And I think again, one of the reasons that they've given is that our technology just isn't good enough to do the sort of target identification type of work that's envisaged. And I think it's rare, isn't it, that we get one of the tech bros say, "Hang on, my product can't do that."
Yeah.
It's perhaps refreshing to hear that. The other thing we've seen in our news in the last 24 hours or so is apparently they intend to hire somebody specifically to check that their systems aren't being used for incompatible purposes and to further war aims, which is a somewhat interesting hire as well. I know there's a form in that area. I know Meta, for example, employed specialists in child exploitation to look over their systems and their product development streams. But I think it's right that we say that, for every irresponsible use of AI, some corporations are thinking about uses and are trying to prevent bad stuff happening on their networks.
We're seeing a lot of folks here in the United States flocking now toward Anthropic's Claude as their AI as a result of this development. So I just thought I'd bring that up. It's very current. Um,
Yeah, no, it's a real interesting development.
Well, good. I think we've covered OpenClaw and other things too in our expansive TechLaw 10, more than 10, number 298. So thanks everyone for joining us. My name's Eric Sinrod. I'm at Dwayne Morris. Jonathan?
Yeah, Jonathan Armstrong, Punter Southall Law, Jonathan.Armstrong at puntersouthall.law. I'm guessing we'll have our email addresses along the bottom of the screen again. We've got a LinkedIn group if you want to continue the debate then. Thanks very much for watching or listening. You can subscribe to the YouTube channel, which will keep you up to date. And if you're listening on the audio version, we do appreciate you tuning in as well.
And for those on audio, EJ Sinrod at DwayneMorris.com. Thank you so much.
See you next time. Thank you.